If there is domestic violence or other alleged abuse, can one parent take the children? And if so, must he or she disclose where the children are staying before or during a divorce?
The issue there is even if there's domestic violence, that is one party alleging that there's domestic violence. It still has not been established via a court. So if I get that question posed to me by a client or potential client, I tell them if the other side is not expected to agree to you leaving the house with the kids, you have to get that issue in front of a judge. So if there's imminent domestic violence issues, get into family court. Family court is a lot more accessible on those issues than Supreme Court is on a divorce case. So file an order of protection, get a family court judge to authorize that either A, you get to leave the house with the kids and therefore you get a temporary order of custody as part of that order of protection filing, or B, the family court judge orders your spouse to leave the former marital residence and therefore you get to stay in that house with the kids. The only other way that you can do it is via an order to show cause in front of the divorce judge with a request for emergency relief, but sometimes that doesn't take as immediately as people would otherwise want it to. Sometimes that takes a few days for a divorce judge to rule on the issue. Sometimes it takes a few weeks for the divorce judge to rule on the issue. Now, if there's already been physical violence, or let's say spouse threatens the person's life or threatens imminent serious bodily harm on the person, then sometimes people have to do what they have to do and leave for safety reasons. And I'm never here to tell a person to stay in the house if somebody is threatening to chop you up with a machete, which I had on a recent case. But in that instance, you want to get into court as soon thereafter as possible. So essentially, if you leave the house, you can get into family court the same day that you leave the house. Likewise, you do have the ability under New York state law to keep your new address confidential. And that's irrespective of whether you enter a domestic violence shelter. If you do, then by domestic violence shelter rules, you have to keep your address confidential. But otherwise, you can make an application, whether your case is pending in family court or Supreme Court, to keep your address confidential, in which case you have to designate an address at which you will receive papers from the court. Usually that's either you leave an address on file with the court that is still kept confidential from your spouse, so that the clerk's office can mail you documentation that your spouse files, or you designate your attorney to receive documentation on your behalf.